Welcome, everyone. First, I just wanted to say Happy Hispanic Heritage Month. Coincidentally, it's also the month in which many countries in Latin America, including Mexico, celebrate their Independence Day. So happy Independence Day to all the countries celebrating this month. Tomorrow, September 17th, is also Constitution and Citizenship Day here in the US. This is to commemorate the day that the founding generation signed the US Constitution over 200 years ago. So happy Constitution Day to us here in the US, and thanks for tuning in to our Thursday's live chat with Chugh. Each week, we cover pressing topics that matter to you and your business. My name is Angelita Chavez, and I'm an immigration attorney and partner with Chugh LLP based out of the Kennewick, Washington branch office. As you may already know, Chugh LLP is a full-service legal accounting and immigration firm that serves businesses across the US, India, and around the world. Today, we will cover the U non-immigrant visa and bona fide determination process for obtaining employment authorization documents, EADs, while the U visa is pending. During our chat, feel free to submit your questions. I'd also like to provide a quick disclaimer before we get started. Please note that our chat today is for informational purposes only. It does not create an attorney-client relationship and does not constitute legal advice. Always verify information with counsel. So, what is the U visa? Well, in October of 2000, Congress created the U non-immigrant visa under the Victims of Trafficking and Violence Protection Act to strengthen law enforcement in investigating and prosecuting crimes. While at the same time, the U visa was intended to protect victims that have suffered substantial mental or physical harm as a result of those crimes and were willing to be helpful to authorities. There is a limit of 10,000 U visas that can be granted each year. While there is no visa cap for family members that are driving status, such as spouses, children, or other eligible members of the principal U petitioner. In order to qualify for a U visa, the victim has to be a victim of a qualifying criminal activity. You also must have suffered substantial physical, mental abuse as a result of being a victim of such criminal activity. You have information about the criminal activity, and you were helpful, or are likely to be helpful in the enforcement, investigation, or prosecution of a crime. Lastly, the crime has to have occurred in the US or in violation of US laws. The process for applying for a U visa requires many forms. So if you have to file a petition for a U visa, you have to file various USCIS forms, waivers, and fees, and supporting evidence to establish your eligibility. This includes Form I-918, the petition for U non-immigrant status, the Form I-918 Supplement B. This is a certification that is completed by a certifying agency. And also, if you are inadmissible, that means you have maybe unlawful presence or other inadmissibility, you have to file Form I-192. This is an application for advance permission to enter as a non-immigrant, and you can request a waiver of that inadmissibility. The person should also submit a statement regarding the criminal activity and the harm that resulted. You also should submit any other evidence to establish eligibility. I do want to give a special note on the Supplement B certification. This certification has to be signed by an official of a certifying law enforcement agency, and that official needs to confirm that the victim was helpful, is currently being helpful, or will likely be helpful in the investigation or prosecution of the case. Certifying agencies include any federal, state, tribal, territorial, or local law enforcement or agencies. These also include prosecutors, judges, or other authorities that have the responsibility to either detect, investigate, or prosecute a qualifying criminal activity, or to convict or sentence that perpetrator. Agencies with criminal investigative jurisdiction are those such as the Child and Adult Protective Services, the Equal Employment Opportunity Commission, EEOC, and federal and state departments of labor. This certification has to be signed, is only valid, the signature on the certification is only valid for 6 months. So once an official has actually signed the certification, your U visa petition should be submitted within those 6 months. Otherwise, you'll probably be required to submit a new, fresh U visa certification. Before our session ends, I also wanted to discuss the bona fide determination EAD process. On June 2021, USCIS announced that it would update its policy manual to include a process known as bona fide determination to issue work permits. As discussed previously, U visa petitioners normally had to wait many years to qualify for initial work permits. With the bona fide determination process, these work permits will hopefully now be issued much sooner than previously. As of June 14, 2021, USCIS is conducting the bona fide determination process and will issue work permits for those that qualify. USCIS considers a U visa petition to be bona fide if the Form I-918 was properly filed and properly completed by the petitioner. The Form I-918B, the certification, was also properly completed and filed and signed by the certifying law enforcement official. There was a personal statement that was submitted detailing the facts of the crimes, and the person is not a threat to national security and otherwise merits favorable discretion. So there are some questions in our chat, so let's go ahead and cover those now. All right, so question one, this person is asking, what if I was a victim of a crime, but the crime was never prosecuted because they fled? Can I still file for a U visa? I think that this person is saying that the perpetrator probably fled and was never eventually arrested or something happened, but they want to know, can they still file for a U visa? The answer is potentially yes. If you meet the basic U visa requirements, the crime was a qualifying crime, you were helpful to the authorities, you have your supplement B that can certify that, and you also have evidence regarding the harm that was suffered, potentially yes, you can still file for a U visa. Thank you for that question. Question two states, I was a victim of a crime many years ago. I even testified in court, but I never filed for a U visa. Can I file it now? Yes, great question. You can still, if you still meet the requirements of the U visa as mentioned previously, it was a qualifying crime, certification B was properly, it is obtained and can be properly submitted. You have evidence regarding the harm, you have your proper waivers and everything. Yes, you can still file it now, even if this crime occurred many years ago. And that's important to note because sometimes folks think that, oh gosh, this crime occurred such a long time ago. We did file police reports, but we never, never filed a U visa at that point. Can I do it now? Yes, you can still potentially do it now. The next question says, what if I have been waiting for my U visa for many years? Will my case go through the bona fide determination process for the work permit? And do I have to take any actions to get this process going? This is another great question. According to the information that we have so far, USCIS will review all pending U visa cases for bona fide determination. If qualified, they will issue an EAD for both new and old pending U visa cases. So you do not have to take any action. Also, there is going to be an information session on October 20th. USCIS will hold this information session and will probably give us better information about the process at that point in time. So we will be updating on this as we get more information. So thank you for that question. There is another, there are a couple more questions, and I think we can cover those as well. This person is asking, how long will it take for me to get my EAD? So I'm assuming that this person is asking about how long they will take to get their EAD based on the bona fide determination process. So unfortunately, we just don't know. DHS has not provided much information about how long that could take. And considering that there are thousands and thousands of pending U visa cases, it can take a long time. We just really don't have that information available right now. There are no time limits available at the USCIS website. But again, hopefully on October 20th, when USCIS holds their information session, we will know more about that process and whether they're going to be doing any sort of expedite process for these things or providing any other avenues to request expedite. We just don't know at this moment in time, but hopefully on October 20th, we will have more information. So thank you for that. There is one more question I see on our chat. Let me just pull it up. The person is asking if I get a bona fide determination and my EAD, so I guess if they get this granted, does this mean that my U visa will be approved? This is a really, really great question, and I'm so glad somebody asked. Unfortunately, no, the answer is no. The bona fide determination process is only considers whether the case was properly completed, the basic requirements are met, and that the applicant is not a threat to national security, doesn't pose any risks, that they, otherwise meet all of the requirements and therefore can get their EAD sooner. But it does not necessarily mean that the case will be approved. It still has to be adjudicated. It still has to go through the proper processes with USCIS to see whether this person actually qualifies for the eventual granting of the U visa, as well as any of the attached waivers. So unfortunately, just getting your EAD and your bona fide determination will not necessarily mean that you will be able to have an approval on your U visa. But again, it's always important to talk to an experienced immigration attorney when you have questions such as these, any specific questions regarding your case, how it was filed, or how long it's been pending. Again, as we've mentioned previously, some folks have been waiting years and years and years, and they still have not been placed on the deferred action docket yet, or the deferred action list to be able to get their EADs. So some folks are waiting quite a long time. So just always speak to an experienced immigration attorney that can help answer your questions. At Chugh, we have many experienced immigration attorneys that would be able to help answer your U visa questions. So I think that is all that we have for now. I don't see any other questions in the chat. Thank you so much for watching. I know this is a short chat, but we're always happy to have consultations with folks and help them answer more case-specific questions. Again, thanks so much for watching. Viewers can send further questions to myself, Angelita, that's ANGELITA.Chavez@chugh.com or info@chugh.com. You can also tune in to our weekly live sessions every Thursday at 11 a.m. Pacific Standard Time and 2 p.m. Eastern Standard Time for more critical insights that can help you and your businesses thrive. Be sure to follow us on LinkedIn, Facebook, YouTube to get notified when our live events begin. You can also visit our website at www.chugh.com. Thank you so much for watching.